Okay, we are live on YouTube and we are live on LinkedIn. Right, cool. That shouldn't be an issue. Yeah, that shouldn't be an issue. Should I start letting people in?
Yes.
Right. Good luck, folks.
Thank you. I'm going to start this when the timer ends. Hello, everyone. We're just going to start when the timer ends. Thank you so much for being here today. And we'll start in another 1.5 minutes. Hello, everyone. Thank you for joining us today. We're going to start the event now. I'm Anushka Jain, and I work as the Associate Policy Counsel for Surveillance and Transparency at Internet Telecom Foundation. Today, we're going to be discussing the draft Indian Telecommunication Bill 2022, which was released for public consultation last week. According to the explanatory note, which accompanies the bill aims to provide a modern and future-ready legal framework for the regulation of telecommunications in India. When enacted, it will repeal the Indian Telegraph Act, the Indian Wireless Telegraphy Act, the Telegraph Wire Unlawful Protection Act 1950, and will also amend certain provisions of the Telecom Regulatory Authority of India Act 1997. Today, I'm going to be talking to two IFF staffers, Tejasvi Panjar, who is the Associate Policy Counsel, and Tanmay Singh, who is our Litigation Counsel. Tejasvi will discuss provisions related to the expanded definitions clause and the licensing requirements, which have also been widely expanded, as well as other provisions, which includes how the bill dilutes tries power, among other things. Tanmay is going to specifically address concerns about provisions related to surveillance and internet shutdowns. Before we start, I just want to mention that the deadline for the submission of the comments in this public consultation is October 20, 2022. After this discussion here today, if you feel that this is an issue worth engaging upon, I genuinely urge all of you to consider sending in your thoughts and comments to DOT who've done this consultation, and try to express your concerns with the bill as well. We will be also sending our comments to the bill, for the bill, to DOT before October 20. Now I'm going to ask Tejasvi to start the discussion. Tejasvi?
Hello, everyone. Thanks for joining in. Thank you, Anushka, for that introduction. I'm very excited to speak with you all today on this topic, especially since it's garnered so much attention in the media. We at IFF have been working on providing rapid responses and in-depth analysis on the bill since the last week, and it gives us immense pleasure to do this members briefing call. I think there needs to be more conversation around this, and more importantly, much more awareness on its potential consequences. Yes. So it would only make sense to start this discussion by understanding how the bill expands the powers given to the central government. So firstly, it expands the very definition of telecommunication services and includes a bunch of services that previously wasn't under its ambit. So what you're looking at on the slide is the new definition under the draft bill. Everything in red is what was earlier not a part of this definition, mainly as defined by the Tri-Act of 1997. So to make it easier for you to comprehend what the scope has expanded to, let me give you some examples of these newly included services. Now, please bear in mind that these terms are not defined in the bill, and some services may overlap with each other. So internet and broadband services are provided by some telecom companies, or telcos as they're colloquially referred to, such as Airtel, but also by Act FiberNet, Excitel, BSNL. You must use some of these. Internet and satellite-based communication services includes services provided by Bharti Airtel, Vodafone Idea, Reliance Jio, etc. Now for in-flight and maritime connectivity services, so far 7 companies have been authorized to provide such services, some of which are Airtel, Jio, TataNet, many more. Now coming to the last 3 and arguably the most important services. Interpersonal communication services, which technically also includes OTT or over-the-top communication services, includes 2 kinds. One, number-based services such as WhatsApp, Signal, or Telegram. And it also includes number-independent services such as like OTT service, communication services such as Google Meet, MS Teams, Jitsi, etc. And last but not the least, machine-to-machine communication services. These refer to services such as your smartwatch or your smart TV, so like your Apple Watches or Fitbits, right? Now, if you move on to the next slide, we'll address why this is important. To understand that, let's quickly go over clause 3, subclause 1 of the draft bill, which essentially gives the central government the exclusive privilege to provide telecommunication services. I promise I'll break this all down, but clause 3, subclause 2, allows the central government, among other things, to prescribe licenses for providing telecommunication services. So what essentially is happening is each and every online communication service provider will have to obtain a specific license from the central government to operate in India. Now, who will this be applicable to? We have already discussed this. All the service providers that you can see on the screen: WhatsApp, Skype, Google Meet, Telegram, MS Teams, Zoom, Facebook Messenger, and so much more. Now, this will result in additional cost and compliance burden for small service providers, and it will also affect the vibrant innovation culture of India. Now, next slide, please. The move towards regulation of OTT communication services has for a long time been a demand raised consistently by traditional telcos. According to the telcos, the lack of equal or same regulations over OTT communication service providers creates an uneven playing field for them, since according to them, OTT services are a substitute of the services provided by them. And that is essentially the same service, same rules argument that telcos have used since a long time. Additionally, telcos have also placed the blame on OTT communication services providers for somehow having stolen profits from them. Over time at IFF, with all the analysis that we've done on this and all the readings that we've done, we dispute all the arguments that you see on the screen. And these are arguments made by traditional telcos. And I'll go through the reasons why one by one. Firstly, both OTT communication services and telcos don't offer identical services. OTT communication services offer multiple functionalities on top of the functions provided by the telcos. So it includes voice calling and instant messaging, but also social networking. For instance, Twitter and Instagram. I can use these platforms to communicate with you as well, right? But their primary function is social networking. Now, the question arises in my head, will such services also be brought within this regulatory ambit? There is no clarity. But if so, it will lead to a lot of ad hocism. You can imagine such issues will have to be dealt with on a case-to-case basis, because again, ambiguity that arises from the wording and the phrasing in the bill. Further, stolen profits argument are unfounded, as there's been immense research on this that OTT services make huge investments in telecom infrastructure and networks, such as data centers, undersea cables, CDNs, edge computing, etc. Even more importantly, they are, as you would imagine, significant revenue generators for telcos. In fact, they're a big engine for creating demand pull for broadband services. And now on a technical level, it is really important to understand that OTTs are essentially internet-based apps. They don't own or work a telegraph. And this is also how TRAI defined it back in 2015. It defined OTT provider as a service provider which offers ICT services, that is information and communication technology services, but neither operates a network nor leases network capacity from a network operator. So while telecom operators are the gatekeepers to broadband internet access and infrastructure, OTT services don't have these controls. So to sum up, this bill, instead of democratizing telecom services in India, consolidates more power with the central government and introduces overburdening regulation on OTT service providers, which may cause anxiety not just to them, but also to OTT service users such as you and I. And okay, here now something really interesting I want to point out. Back in 2020, when TRAI released a consultation framework on OTT regulation, several stakeholders who were in favor of cross-border data transfer raised concerns about the government's inability to intercept personal communication and information stored in data servers located abroad in the absence of data localization norms. So essentially what they said, these unnamed stakeholders, in the interest of national security, the government might have to intercept our communication. The communication say I have with someone, my private communications or chats on WhatsApp. But how will you intercept it if this data is stored abroad and not in India? What would you need for that? Data localization norms. So this was a point that was raised in the consultation framework that was released by TRAI back in 2020, which we engaged with extensively. And so what can happen? And this is just something to think about, right? When the government makes the rules, once and if it becomes an act, it may now ask the services to store data locally in India, and this could include personal and sensitive information. So it will give them even more powers to intercept our private communication and break encryption. Now, this is something that Tanmay, my colleague, given his expertise, will explain to you. So I won't go into it anymore, but I would just like to say that such a licensing requirement confers excessive discretion to the government and adversely affects our privacy. Okay, next slide. Moving forward, the bill, in addition to expanding the central government's powers for granting licenses, the central government has also diluted the powers of the Telecom Regulatory Authority of India, or TRAI, under clause 46 of the bill. So for this, they've deleted certain provisions, key provisions of the TRAI Act of 1997. These provisions of the TRAI Act are included in the boxes that you can see on the slide. So first one, clause 46 subclause F of the bill has deleted the key proviso of TRAI Act under which the government, prior to issuing the new license to a service provider, had to ask the regulator, that is TRAI, for recommendations. And the TRAI would have to forward recommendations within 60 days of the government making such a request. Now, this has been deleted. Clause 446G deleted a proviso which empowered TRAI to ask the central government to furnish necessary information or documents which the latter would have to hand over within 7 days of receipt of such request. Now, a provision like this in the TRAI Act of 1997 was a good step, right? I mean, it brought checks and balances and accountability, but given with this bill, it deletes these two provisos. This is an unfortunate instance wherein the central government is strengthening its own power and reducing accountability. Talking about unfortunate instances, in the next slide, we come to clause 4, and that doesn't let us down either. Clause 4, subclause 7 requires every entity which will receive a license to unequivocally identify the person to whom it provides services through a verifiable mode of identification. Now, what this mode of identification will be, we don't know yet. The users may be bound to give details under KYC, but we do know that the identity of the person receiving the service will have to be established unequivocally, and that means leaving no doubt. Coming to clause 4, subclause 8, it states that the identity of the sender of a message using telecommunication services must be available to the receiver. So if you're sending me a message, I must know who the person is who's sending me the message. I must know the identity. Now, these provisions essentially strip away the user's right to stay anonymous and puts an obligation on the service providers to identify with complete assurity, mind you, every user. Now, although there is some hope in clause 4, subclause 8, which says, unless otherwise specified by the government, it does give us some hope, but such a broad and excessive requirement in the absence of a data protection law fails to prioritize user safety and security. Okay, next slide. And I promise to hand it over to my colleague Tanmay after this. We come to the provisions that gives powers to the central government in case of breach of terms and conditions of license. Now, clause 7 of the bill empowers the government to suspend for a specific period, curtail the period of, revoke, and or vary a license, registration, authorization, or assignment. So now if you look at the box on your right, the first paragraph, you read the provisions the Telegraph Act of 1885 had on penalties for a breach. And as per section 8 of this act, the central government was empowered to revoke licenses following the breach of any conditions or in default of a payment. It didn't, however, and here I'm talking about the Telegraph Act. It did not, however, have provisions for suspension of the license. Now coming back to the draft bill, clause 7 also empowers the central government to impose a penalty as specified in Schedule 4, and we'll come to that, after determining the category of severity of the breach. So as per Schedule 4, a penalty, say for a non-severe breach, is a written warning. But for a severe breach, it is up to 5 crore. So now let's compare it with the Telegraph Act. Now, if you look at the box on your right, the punishment for breach was limited to a fine of ₹1,000 and a further fine up to ₹500 for every week during which the breach continued. While the penalty has significantly increased, I do want to point out that some guidance and safeguards have been provided. The clause does provide the concerned party an opportunity to be heard. So in fairness, that safeguard does exist, but given the decision of suspending and revoking a license rests solely with the central government, there definitely needs to be more safeguards. That was it from my end, and trust me, there is so much more to say and so much more to cover, for which I will request my colleague Tanmay to take over.
Thanks a lot, Tejasvi. And thanks to everybody who has joined this mid-evening on a Friday. I know that you guys are likely waiting for your weekend to begin because Friday. And thanks also to everybody who's joining in on the live streams on YouTube and Twitter and LinkedIn and everywhere. You guys who are watching the live streams, if you're feeling some FOMO about not being in the Zoom room and having the full interactive experience with us, please feel free to become members and donors and chat with us one-on-one anytime you like. I'm going to come to, mainly I'll talk about chapter 6. of this draft bill, the one that talks about public safety, national security, and all of those things. But before we start that, I should set out that these are not reforms. This is just a new bill which will become a new act. In fairness to the government, they have also not pretended that these are reforms. The introduction of the bill, which I have on screen and also in front of me, has 3 paragraphs. And the thrust of the 3 paragraphs is economic development, public infrastructure necessary to make spectrum available, universal telecommunication services, efficient management use, all of these things. There was an explanatory note that accompanied the bill, which was made fun of because of certain comments that were there that seemed a little bit out of place. The explanatory note also says that suggestions have been noted for inclusion in future reforms. Reforms may happen. These are not reforms. The reason why I say that is on the next slide, which we'll see as soon as the slide gets changed. And now, there we go. So in 1885, the Telegraph Act had been enacted by the British government that existed at the time. And what we have in this bill, at least in terms of the surveillance provision and the internet shutdown provision, is more or less the exact same thing. So if you have the time and if you can read from there, if you want to read through the whole thing, you will note that it is exactly word to word the exact same thing with 2 small changes at the very bottom, where in the 3rd last line, the Telegraph Act says transmitted or received by any telegraph. That has been changed to any telecommunication services or telecommunication network. And where in the 2nd last, it says shall be disclosed to the government making the order, that has been changed to the officer mentioned in such order. Those are the only 2 updates they have made to the surveillance provision in 2022 over a law that was enacted by the British in 1885. I did the maths, and that's 137 years. And you might ask yourself, I certainly ask myself, what has changed in these 137 years, even though the surveillance provisions appear not to have, which is we have since gained independence. We have since drafted and adopted and given to ourselves, we the people have given to ourselves a Constitution of India, which has Article 14, it has Article 19, it has Article 21. It grants you the freedom of speech. It grants you the freedom of life and due process. Over time, in the last 75 years, we're celebrating the Amrit Mahotsav this year with lots of pomp and vigor. And there have been several Supreme Court decisions that have expanded, restricted, tested, retested the scope and ambit of our fundamental rights. In case of surveillance provisions and internet shutdown provisions, some of the big important ones are the 2 Puttaswamy cases of 2017 and 2019. For internet suspensions, the big one is Anuradha Bhasin from 2020. These Supreme Court landmark judgments have come in just the last 5 years. So it's not like any government of the day has forgotten that these matters have happened. They're right there. But it appears that nothing from that has been brought into these provisions. Now, what ought to have been brought? The 2 Puttaswamy cases expanded on the right to privacy. The right to privacy was recognized for the first time as a constitutional fundamental right across Part 3 of the Constitution, Article 14, Article 19, Article 21. It is a fundamental right now. There are very, very detailed tests of proportionality laid down for how privacy could possibly be infringed by the government on occasion. And the law recognizes that you don't have an absolute right to privacy. There are situations where the government will be required to impose restrictions on your right to privacy, just as it does for speech and any other right. And the way to do that would be through a 4-pronged proportionality analysis, where you must first see that any impact on your privacy, negative impact, is done by means of a law. That law has a suitable goal. The law is suitable to meet that goal. there is no other less intrusive option available. None of this features in the text of this bill. And if you see the internet shutdown provision, which Anushka has read my mind and changed the slide, the internet shutdown provision is an interesting one, because in 1885, the internet didn't exist. It would have been difficult for somebody less than Nostradamus to predict the internet type something is going to come. So once the internet did come and governments realized, okay, it's fun to shut the internet down from time to time, and then they looked around for how do we do this, they found the provisions of section 5.2 of the Telegraph Act. If you look at the bottom, and it's a wordy, verbose provision, so I'm just gonna skip to the bottom where it says, direct that any message or class of messages to or from any person or class of persons shall not be transmitted. And the government said, okay, this is fine. Under this, I can suspend internet services. Over time, since 1885, other than the invention of the internet, what has happened is we have in 2020, January 2020, we have in the Anuradha Bhasin received a landmark judgment from the Supreme Court that recognizes that your right to speech and your right to trade and profession over the medium of the internet is similarly protected by the Constitution as it is in the offline world, which essentially means any suspension of internet services is a direct impact on your fundamental rights. And nobody is saying that that cannot be done. The Constitution itself recognizes that there are situations where you would need to have reasonable restrictions on your free speech. And I absolutely get that. But all of the safeguards, all of the proportionality analyses, all of the independent review methods that exist, they have again not been converted into the text of this bill. Now, let's go to the next slide, where you will see that both under the Telegraph Act, both of these powers, surveillance and internet shutdowns, and those are the two big ones that I'll focus on today. Both of those powers were operationalized by rules. So there were broad powers under section 5.2, and then how that would actually work in practice was sort of explained in the rules. For surveillance, it was rule 419A of the Telegraph rules. And for internet suspensions, earlier governments used to do it by single line orders in under section 144 of the CRPC. In 2017, they issued these temporary suspension of telecommunication services rules, which I call the TSTS rules. And then they started suspending internet services under that. What this bill does is all existing rules to continue as they are, which, I mean, okay, it's fine because you need sort of legal certainty and legal continuity. And then perhaps one day they will come back to re-examine these rules. But there's nothing that requires them to do that. That's in the realm of speculation. They may well not revisit the rules, which is not a great outcome. Because in Anuradha Bhasin, the Supreme Court records that these telecom suspension rules are incomplete. The Supreme Court records in its judgment, and you can control F and you'll find it, that the Supreme Court says, because the rules are not enough to take care of this situation, we need to step in and issue guidelines that need to be followed. Now, as it so happens that government functionaries on the ground who issue internet suspension orders, who issue surveillance orders, they have not read every Supreme Court judgment out there. There are several in RTIs we found out that there is at least one state that didn't even know that the Anuradha Bhasin judgment has come and that they have any directions to follow. So what is required is that the rules themselves, the text of the rules, because that is what the government officers read. What is required is that the text of the rules are also amended side by side. Currently, there is no indication that that is going to happen. And if we move to the next slide, I will give you concrete suggestions, at least what I am thinking are absolutely necessary, which are things that have also been recognized by the Supreme Court. For example, in the second Puttaswamy judgment in 2019, Justice Sikri had said that there should be judicial review or oversight of surveillance orders. So how surveillance currently works, and it's a bit intuitive, is that the government issues a surveillance order, and then these things are highly confidential. complete opacity. In fact, to the extent that the government and the Ministry of Home Affairs, to be specific, has over years completely blocked, stonewalled any of our efforts to find out just the total number of orders they issue. We asked them in an RTI, boss, like, just tell us the total number of orders you issue in a month or in a year or whatever. Don't tell us anybody's name. Don't tell us anybody's phone number. Don't tell us anybody's address, nothing. Just tell us the total number, aggregate, anonymous. They said no. Highly confidential, we can't tell you. Why? There is no reason for it to be this confidential. Second, there needs to be an independent judicial review of every surveillance order that is issued, because it is an administrative decision which impacts your fundamental rights of speech, of privacy, of your right to assembly, and many of them. Currently, there is no review method. And if there is, it is entirely within the executive setup. And this is detrimental to the concept of separation of powers, which is essential in a democracy. The other thing, and this is a bit out there, is that there is no legal recourse to a surveilled person. And the reason why I bring this up, the reason why I say this, and you may fairly turn around or write in the comments that, well, if you tell a surveilled person that they are being surveilled, then it will defeat the purpose. But that's not where I am. The other thing that has happened in these 137 years is the Pegasus controversy, is that about 300 or so Indians, nearly none of them terrorists to the best of my knowledge, just journalists, opposition politicians, political dissidents, activists, human rights activists, those kinds of people. Pegasus was found on their phones, and I don't need to explain Pegasus to this crowd. You guys all know what that is. You know that we've been in court for about a year or so trying to get some sense of what has happened. Though no lessons have been learned from Pegasus. By the way, very important to note that the central government did not participate in the legal proceedings. Once the court ordered an investigative committee to be formed and investigate the allegations of Pegasus, the court, in open court, the then Chief Justice of India observed that the central government did not participate in those proceedings either. Complete impunity, they managed to get away. And if you look at the text of the law that existed then, and if you look at the text of the law that will exist from now on, if this bill becomes a law, there is no procedural safeguard to us. There is absolutely nothing anybody can do. And that's something really worth thinking about. So there's no accountability. And similar points exist for the internet shutdowns, which we'll come to in the next slide. Now, is that now in the Anuradha Bhasin judgment, after Justice Ramanna, he wasn't chief then, had said that there exists lacunae in the TSTS rules. We are giving you these broad directions that you need to follow. The telecom suspension rules were amended. In 2020, they were amended to only take one guideline, which is that internet shutdowns cannot be ordered for more than 15 days at a time. That's the only one they took. Currently, some of the problems with the telecom suspension rules are that there is a review committee, but it is within the executive branch of government. So in a state, it is a 3-member committee, which is headed by the chief secretary of the state, has the law secretary, and one more secretary other than the home secretary. Reason for that being that the home secretary is the one who's issuing the order in the first place. This review committee is a completely toothless body. It has absolutely no powers at all. Its only remit is that it will receive this suspension order, it will read the suspension order, and then write on a piece of paper whether the suspension order follows the text of the rules, satisfy the conditions or the criteria of the act or not. If it doesn't, if the review committee finds that the internet suspension order has been issued illegally or improperly or against the law, there's nothing it can do. So it's really, really quite a pointless exercise. It is so pointless that when we filed an RTI in Rajasthan about the review committee, we received a reply that says the review committee has never met. It never meets, it only approves. They did not even say considers. It only approves internet suspension orders by circulation. Now it's completely unhelpful. There's just, you might as well not do it. What we need is an independent review committee body which has members from branches of government that are not the executive. So some judicial members, some technical members, it needs a little bit of independence. One of the big ones is that there is no reason for these orders not to be proactively published. And the Supreme Court has issued this guideline that you have to publish all of these orders. The Supreme Court specifically says to enable affected persons to challenge the orders in writ proceedings. And that's your right under 226 of the Constitution and 32 of the Constitution. If something is affecting you, you should have the right to challenge it in court. That gets defeated by non-publication of these orders. It rarely happens. There are several states that do it. I'll be fair to them. Jammu and Kashmir puts it up on their website, albeit they do it 2 months later. So by then, there is not much you can do about it. There are several states that will not even give you the internet suspension orders under RTI proceedings. So that's a whole different battle that could have been fought in this bill, but has not been. So that's all I'll say about this. Let's see what's on the next slide. Great. Oh, cool. I'm done. That's all from me. Now it's back to Anushka and Tejasvi. But before I mute myself, I will say if literally any of that was helpful and/or interesting, please consider becoming a member and/or donor to IFF. We keep doing these things often enough.
Thank you, Tanmay. Thank you, Tejasvi, throwing light on those provisions. I understand that it is a little difficult to understand these provisions, especially because they're replacing 3 laws and replacing certain provisions in another law. But basically, the entire essence is that they're trying to consolidate everything into one bill related to telecommunication in India. However, what they fail to do is actually make sure that the law is in line with the times. It mostly feels like a reproduction of older laws which has been consolidated. Now, what we're going to do is, because this is a members briefing call, and like Tanmay said, we do this for our members. We're going to end the live stream here, and we're going to allow IFF members who've joined this call to ask questions to the staff. If you also want to be a part of that process, I encourage you to become an IFF member today. You can go to our website and become a member, and that will allow you to engage with us in a more meaningful manner. Last thing that I want to say is that October 20th is the deadline to send in your submission for this consultation process. So please do consider engaging in the entire process and make your voice heard. Thank you so much for being here today.